Assalamualaikum. Today we will present about retirement, appointment and removal of trustee. Okay, the first one I will explain about the intro. The appointment, there is one occasion when it's made necessary to appoint trustee. The creation is new trust. Like can I explain is whether inter vivos or by will the during the continuous and exit trust, either the replacement of the trustee and additional trustee. Okay, the first one is creation of the new trust. Okay, it is like the shelter or tester, either when create a trust, usually appointed the first trustee. Okay, and next is continuous of the trust. Continuous of the trust is when the trust is created, whether the inter vivos or by will are the trust property, real or personal, invest the trustee in joint tenants. Okay, the effect on the debt is trustee with property devolve on the survivor. Okay, and then I will explain about retirement. Retirement divide two forms, is either accompanying a finally disruption to trust asset and beneficiary, or retirement is a favor of the new incoming trustee. Okay, the transactions between the outgoing and incoming trustee is usually can consequent process. Okay. The next one is removal of trustee. Okay, the removal of trustee include a situation when the trustee in a conflict, the trustee appropriates or deal with trust asset for their own advantage, friction with beneficiary, or an entire breakdown of the relationship acquired. Okay, the beneficiary welfare and the competent administration of the trustee is paramount. Okay, that's all. I will pass to Amira.
My name is Nur Amira binti Abdul Ghafur and my matric number is 191002. My point is about the appointment of trustees. Who can appoint trustees? Court has inherent jurisdiction in action for the administration of trust to appoint or remove a trustees compulsory. Court will need to look powers contained in the instruments. So we are going to talk about the appointment of trustees. In the general rule of appointment of trustees, any person capable of holding property in law could be made a trustee, and it is for the settlor or testator to decide the basis on which a person is chosen. The court is under no duty or obligation to determine the reasons for the deceased appointment of the defendant as the trustees of her estate. This can be seen in the case of Puah Cui Har and Amanah Raya Berhad. So now we are going to talk about who may be a trustee. First, minor. Minor cannot be appointed as a trustee because minor can't hold a legal estate. An infant may become a resulting or constructive trustee of personality. In the case of R. Vinogradov, 1935, a child of 4 years was able to hold property on resulting trust. Second is crown. Opposition. Crown cannot be trustees. Accepted principle of vicarious liability. Third is judicial trustees. Judicial trustees is an individual or corporation appointed by the court under Judicial Trustees Act. Rationale: to provide a middle course in cases administration of the estate by ordinary trustees had broken down. Section 40 of Trustees Act 1949, power of appointing new or additional trustees. Section 40, subsection 1, where a trustee is either original or substitute and whether appointed by a court or otherwise, number 1 is dead, or number 2 remains out of Malaysia for more than 12 months, or number 3 desire to be discharged from all or any of the trust or power reposed in or conferred on him, or number 5, refuses or is unfit to act therein, or number 6, is incapable of acting therein, or number 7, is a minor. Who may exercise power of appointment? Section 40, subsection 1 stated that it may be exercised by the following persons subject to the restrictions imposed by this Act on the number of trustees. Section 40, subsection 1A, the person or persons nominated for the purpose of appointing new trustees by the instrument, if any, creating the trust, or B, if there is no such person or no such persons able and willing to act, then the surviving or continuing trustees or trustee for the time being or the personal representative of the last surviving or continuing trustee. Appointment by the court. This can be found under Section 45, subsection 1A of the Trustees Act. Similar with Section 41 of the English Trustees Act 1952. Statutory formula used by the court where it is inexpedient, difficult or impracticable so to do without the assistance of the court. Section 45 of Trustees Act 1949. Power of court to appoint new trustees. Section 45, subsection 1A, the court may, whenever it is expedient, to appoint a new trustee or new trustees, and it is found inexpedient, difficult, or impracticable so to do without the assistance of the court, make an order appointing a new trustee or new trustee, either in substitution for or in addition to any existing trustee or trustees, or although there is no existing trustee. Section 45, subsection 1b, in particular and without prejudice to the generality of the foregoing provision, the court may make an order appointing a new trustee in substitution for a trustee who, number 1, is sentenced to a term of imprisonment, or number 2, is mentally disordered, or number 3, is a person of unsound mind, number 4, is bankrupt, or number 5, is a corporation which is in liquidation or has been dissolved. Section 45, subsection 2, an order under this section and any consequential vesting order or conveyance shall not operate further or otherwise as a discharge to any former or continuing trustee that an appointment of new trustees under any power for that purpose contained in any instrument would have operated. Section 45, subsection 3, nothing in this section gives power to appoint an executor or administrator. Case related to this is Biku Daeng and others and Maung Shui Tun 1980. So now we are going to talk about how many trustees. Okay, under section 39, this section talks about limitation of the number of trustees. In section 39, subsection 1, in the case of settlements and disposition on trust of property, whether movable or immovable, made or coming into operation on or after the material date. A. The number of trustees thereof shall not in any case exceed 4, and when more than 4 persons are named as such trustees, the 4 first named who are able and willing to act shall alone be the trustees, and the other person named shall not be trustees unless appointed on the occurrence of a vacancy. And B. The number of the trustees shall not be increased beyond 4. Subsection 2, the restriction hereby imposed on the number of trustees do not apply in the case of property vested in trustees for charitable, religious, or public purposes.
Okay, now I will proceed with retirement of trustee. The meaning of retirement is a discharge from further responsibility and liability under the trust. A trust should not retire when faced with disputes among beneficiaries and leave them to settle their differences among themselves. A trustee will usually retire voluntarily under the statutory power contained in the Trustee Act 1925. In the Section 39, Subsection 1, a trustee can retire voluntarily if two people remain after his retirement, but must do so by date which is signed by all relevant persons. For example, the person who has the power to appoint trustees and the continuing trustees as well as the retiring trustee. For illustration, Afrina, Nisa, and Afnita are appointed trustees of a trust. Nisa wishes to retire and can do so, as Afrina and Afnita will remain as trustees. Afrina and Afnita both need to agree to Nisa's retirement, but Nisa does not need to be replaced. If Nisa's retirement would leave only one trustee, then it would be necessary to replace her. This can occur simultaneously in the same day. Any person who has been given the power to appoint new trustees by the trustee can appoint a replacement for Lisa. If there is no such appointer, the remaining trustees have the power to appoint a replacement of Lisa. There are four ways to retirement. First one is under an express power in the trust instrument. The trust provision may expressly provide for the retirement of trustees. Second is statutory provision. In the Section 40, Subsection 1, this provision enables a trustee to retire desires to be discharged if he is being replaced by another trustee or trustees. In the Section 43, Subsection 1, it allows the retirement of a trustee without new appointment subject to following conditions. A minimum of two trustees or a trust corporation will remain after his retirement. B. His co-trustee and such person empowered to appoint new trustees consent to his retirement. And C. His declaration to retire must be in writing. Third is consent of all beneficiaries. If the trustee can obtain the consent of all the beneficiaries who must be of all full age and surgeries, he may retire. Whether the beneficiaries can allow a trustee to retire without the consent of his co-trustees is doubtful. The meaning of surgeries here is having full legal capacity to act on one's own behalf. And the last one is under an order of the court. In the Section 45, the court may make an order appointing new trustee or substitutes in prescribed manner. Court also has no inherent jurisdiction to allow trustee to retire.
Okay, Assalamualaikum. I will present about the retirement. The first one is retirement is the withdrawal from one position or occupation or from one active work life. A person may also semi-retire by reducing work hours. Most developed countries have a system to provide pension of the retirement in old age funded by the employer or the state. Retirement is a pension is the consideration of the right the words in the many society, hard ideology, social, culture, and political battle have been fought over whether this is a right. History of the retirement. Retirement of the operative of the living on one job or crease or work after reaching a certain age have around since 18th century. Women have the average life expectancy between 26 until 40 years old. So retirement age, a person may retire is the whatever age they please. However, a country tax law or state or age pension rules usually means that is a given country a certain age in the order of the standard retirement age. Standard retirement age varies from the country to the country, but it is generally between 50 until 70 years. So factor affecting decision. Retirement funding education is a big factor that affects the successful individual retirement experience. Knowledge is affect an individual retirement decision by a simple finding knowledgeable retirement options such as individual retirement account and employer-sponsored plans. The pattern cannot be explained by different financial incentives and to retire at this age since typically retired benefit at this age were obligatory fair. So for the early retirement is generally considered to be early if the occur before the age or tenure need for the eligibility for support and fund for government or employee provide such. Early retirement can also be used as the optimist term for being terminated from employee because typical retirement age. So life after retirement might concern with employee life change. A retired worker might move to new location, for example, a retirement community, thereby have less friendly contacts with their provide social contacts and adopting a new lifestyle. Some retirement people even choose to go and live in a warmer climate will be not to the retirement migration. Thank you.
Assalamualaikum and good evening to Madam and my fellow friends. Today I will be presenting about the removal of trustee. For the definition, trustee obligations and duties are set out in both the trustee and also in law. Trustees should not use their powers unreasonably and at all times should act in accordance with the terms of the trustee. It goes without saying that a trustee must act in the best interest of the trust. Next is the legislation. In Section 36 of Trustee Act 1925 provides that where a trustee, either original or substitute, and whether appointed by a court or otherwise, is dead or remains out of the United Kingdom for more than 12 months or desire to be discharged from all or any of the trust or power reposed in or conferred on him, or refuses or is unfit to act therein, or is incapable of acting therein, or is an infant, then subject to the restrictions imposed by this Act on the number of trustees. Next, in Section 36, Sub 9 of Trustee Act 1925, states that where a trustee who lacks of capacity is also a beneficiary of the trust, then it is necessary to make an application for that person removal to the Court of Protection, the court which deals with matters of physical and mental welfare. While in Section 36 of Trustee Act 1925 states that this remedy is not automatically available to beneficiaries unless they are also trustees or they have power to remove trustees under the trust instrument. And lastly, in Section 19 of Trust of Land and Appointment of Trustee Act 1996, which provides as follows: there is no person nominated for the purpose of appointing new trustee by the instrument, if any, creating the trust, and the beneficiaries under the trust are full of age and capacity and taken together are absolutely entitled to the property subject to the trust. Next is the jurisdiction. In the case of Letter State against Browers 1884, in which Lord Blackburn, sitting in the South African court, summarised the position. If satisfied that the continuance of the trustee will prevent the trust being properly executed, the trustee might be removed. It must always be borne in mind that trustee exists for the benefit of those to whom the creator of the trust has given the trust estate. In conclusion, when the court is considering exercising its jurisdiction to remove a trustee, it will be concerned with the extent to which the trust property is at risk, the ability of the trustee to administer the trust, the needs of the beneficiaries, and the extent to which hostility between trustees causes the trust to be poorly administered. Thank you. That's all from me.
Okay, now I will proceed with fiduciary nature of trusteeship. Fiduciary duty is a trust is not entitled to receive any benefit from his position as a trustee. A trustee's fiduciary duty can be divided into a few sub-duties. First, duty not to allow his interests and duties to conflict, and second, duty not to take any secret profit. Duty not to allow his interests and duties to conflict. A trustee who derives any incidental profits from his position as a trustee will be held in breach of the trust. In the case of Kish against Sanford, a landlord refused to renew a lease to a trustee for the benefit of a minor. The trustee then took a new lease for his own benefit. The landlord was happy to give the trustee the lease instead of letting the minor enter into the lease. When the minor grew up, he sued the trustee for the profit that he had been making by getting the lease. The court held that a trustee of a lease may not renew a lease for his own benefit but holds the renewed lease to form a constructive trust for the beneficiaries. The court forbade the trustees to take for himself a renewed term under a lease which he held for the benefit of an infant. Second is duty not to take any secret profit. A trustee has a duty to not to take any secret profit unless authorized by the trust instrument by the beneficiaries in full legal capacity or by the court. If a trustee being in a fiduciary relationship secures a benefit for himself by taking advantage of the trust, equity will not allow him to retain the benefit and he or she shall hold the benefit under a constructive trust. Misuse of confidential information. In the case of appointment against Phipps, after a meeting with the directors of a company, a solicitor took the opportunity to recognize the company in which the trust had a minority shareholding by purchasing more shares for the trust. As the shares increased in value, so did the shares which he purported to purchase for himself, thus resulting in a profit. However, a purchase of more shares for the trust was in fact prohibited unless authorized by the court. The court held that the solicitor was liable to account for the profit he made in breach of his duty. Purchase of trust property, self-dealing rule. General rule is a trustee cannot involve in self-dealing with property belonging to the trust even if the trustee has retired or trustees cannot purchase trust property for himself. In the case of Campbell against Walker, the testator left all of his personal estate to the trustee in trust and appointed him to sell those properties after his death. The trustee subsequently repurchased the trust properties through a representative. The plaintiff's testicle trust, after knowing this, sought the sale to be set aside. The court held that the sale is set aside as the plaintiff, as the buyer of the trust, was not satisfied with the sale and he has the right to resign the sale despite of the trustees are the bona fide purchaser who purchased the properties at a fair, open sale, and there is no fraud and mismanagement or negligence appraised before the court. For exception to self-dealing, we can say the case in holder against holder, the testator appointed his son as trustee. Later, the son has discharged himself as trustee. The son purchased the farm, which is part of the trust property. The court held that the transaction was valid on the basis that there is no interference in the administration of the estate.
Okay, I will explain about the fiduciary. Purchase of the beneficial interest of fair dealing, a trustee may be bound the trust provided that is distinct, clear contract providing that the trust enters to the trustee and for the case Tito and Wedo, the rule is that if trustee purchase to the benefit interest of any of his beneficiary, the transaction is not voidable as the right but can set in aside until the trustee can show that he has been taken no advantage for his position and has made a full disclosure to the beneficiary and that the transaction was fair and honest. So the second next is the director fees, where trustee are appointed a director to the company, to the and shareholder to the relating company and director to the obtained regarding after and schedule profit. Pre Kamadam trustee use their position in appoint themselves as the director of the company, were held liable to the account for the remuneration they receive. The held is the trustee has put themselves in the position where their duty and interest conflict and was thus liable to the account to the trust or the fee they receive as director. The next is competitive of the trust. A trust is the prohibited from the competing with a business belonging trust. Thompson, the tester, as involved to the yes broking business. The trustee wanted to set up a similar business in the same locality. The held is a court order to the injunction returned to the trustee because his plan would have taken trade away from the trust business. The amount the breach of the trust fee as a personal interest was in the conflict with his duty of the protection to the beneficiary interest. Okay, the next is misuse of the confidential information. Board of based on the case brought against Steve after a meeting with the director of the company, a solicitor took the opportunity to organize the company is which the trust and minor shareholding by purchasing more share for the trust. As the share increased the value, so did the share which he put to the purchase for himself, thus resulting in a prohibited. However, a purchaser of the more share of the trust was the fact prohibited unless authorized by the court. The held if the solicitor was the liable account for the profit and the breach of duty. So that's all from me. Thank you. Okay, for the conclusion, I will conclude like the transaction between the outgoing and incoming trustee reasonable the name of Kim. The trustee entitled the reason security of the liability of incoming or outgoing trustee when have reasonable of the transaction agreements. So however, the application of the direction will always be fallback when agreement cannot be reached, and the court will be support on reasonable trustee. So that's all from us. Thank you.